She looked at me and said, "I don't think you understand who I am." I said, "I don't need to. Sit down." She didn't sit down. That was her first mistake. Her second mistake came 11 minutes later, and it was considerably worse. But I want to tell you about the first one because the first one set the tone for everything that followed, and because the way a person walks into a room tells you almost everything you need to know about how they're going to leave it. Her name was Vivian Colt, 41 years old. Her husband ran a private equity firm. She wore the kind of jewelry that doesn't need to announce itself and did anyway. She had come to my courtroom to dispute a $4,200 claim filed against her by a woman named Daria Okonkwo, her former housekeeper of 6 years, for unpaid wages, wrongful termination, and what Daria's filing described as the deliberate destruction of personal property. Vivian Colt had not come to settle. She had come to perform. And for the first 7 minutes, it almost worked. Daria Okonkwo arrived at 9:45, 15 minutes early. She had taken 2 buses to get to the courthouse because she didn't own a car, a fact I would learn later, not from her testimony, but from a detail in her filing about transportation costs incurred attending this hearing. She sat at the plaintiff's table with a folder she had organized herself, tabs color-coded, each exhibit labeled in handwriting that was careful and precise and slightly formal in the way that handwriting is formal when English is a second language, and the writer understands that precision is a form of respect. She had worked for Vivian Colt for 6 years. She had cleaned the house, all 4 floors of it, plus the basement gym and the detached guest suite, managed the household schedule, coordinated with the cleaning supply company, supervised deliveries, and cared for the Colt family's 2 dogs when the family traveled, which was frequently. She had been paid $18 per hour in cash every Friday without a formal contract. The cash and no contract arrangement had been Vivian's insistence, not Daria's preference. Daria had asked about a formal agreement in the first month. Vivian had said she preferred to keep things flexible. Daria had understood what flexible meant. She had accepted it anyway because the work was consistent, the rate was fair, and she needed both. 8 weeks ago, Vivian had told her she was no longer needed. "Not we're letting you go with 2 weeks' notice and a reference letter. Not we're making some changes with time to find something else." She had walked into the kitchen on a Tuesday morning, looked at Daria, and said, "We've decided to go in a different direction. You can finish today." 6 years of showing up. One Tuesday morning, finish today. Daria had finished the day. Daria had finished the day. She had cleaned everything she would normally clean, completed everything she would normally complete, and left the house the way she always left it, immaculate, because that was what she did and who she was. She had also, before leaving, retrieved the plastic container she kept on the top shelf of the laundry room closet. Inside it, 6 years of handwritten time logs. Every day, start time, end time, tasks completed. She had kept them from the beginning because her mother, who had also done domestic work her entire life, had told her once, "Always write it down, because the day will come when someone says you didn't do what you did, and you need to be able to prove them wrong." Her mother had been right about that. 2 days after Daria's last day, she had gone back to the house to retrieve a personal item she had left behind. A small framed photograph she kept in the laundry room, a picture of her daughter taken at her school's graduation ceremony 3 years earlier. The photograph was gone. Not misplaced, gone. Vivian, she would later learn from a neighbor who witnessed it, had thrown away a box of items from the laundry room the morning after Daria's last day, describing them in the neighbor's hearing as clutter the help left behind. Clutter, her daughter's graduation photograph. Daria had filed the claim the following week, unpaid wages for the final 2 weeks. Vivian had not paid her for the last 14 days of work, claiming the termination made payment subject to review. Wrongful termination without the legally required notice period under state domestic worker protection law, and replacement value of the photograph, which could not be replaced at any price because the negative no longer existed, and that day was gone. She had listed the photograph's value at $1, not because she believed it was worth $1, because she couldn't put a number on what it was actually worth, and she wasn't going to try. I want you to remember that detail, the $1 photograph, because it comes back. Vivian Colt arrived at 9:58, 2 minutes before the hearing, not late, but not early, the timing of someone who has calculated exactly how much punctuality is required and given precisely that amount, no more, no margin for the other party, no acknowledgement that the other party might have been here for 15 minutes already. She was accompanied by an attorney named Thomas Redfield, who specialized in employment disputes, had 20 years of experience doing so, and had clearly been briefed thoroughly on the case. He carried his files with the efficiency of someone who has handled many cases like this one and knows exactly how they typically resolve. He sat down quickly and arranged his papers without looking up. Vivian Colt did not sit down quickly. She was accompanied, in a manner of speaking, by the specific energy of someone who has never lost anything they didn't choose to lose, and who has arrived at a municipal courtroom the same way they might arrive at an appointment with a contractor who has disappointed them, fully intending to resolve it on their terms quickly and move on with their day. She looked at the courtroom the way some people look at hotel rooms that fall short of the photographs. She looked at Daria, a single, brief glance, the kind of look that doesn't really see what it's looking at, and then away. She looked at me, and she said it. I don't think you understand who I am. Not to her attorney, not under her breath, not as a quiet aside. To me, directly, at full conversational volume, clearly enough that my clerk looked up from her notes, and the couple in the second row, who had come for an entirely different case, both turned their heads. I said, I don't need to. Sit down. She didn't sit down immediately. She held my gaze for a moment, the specific pause of someone who was accustomed to pauses producing a different result. And then, slowly, with the careful deliberateness of someone performing compliance rather than enacting it, she sat. Her attorney said nothing. He was experienced enough to know that whatever had just happened was entirely his client's doing, and well outside anything he could walk back. I called the case. Tell me where you're watching this from before I keep going. Chicago, Lagos, London, Mumbai, wherever you are. Because what Vivian Colt did next is the kind of thing that happens everywhere, in every city, in every room, where someone has decided that certain people's time doesn't count the same as their own. Drop your city in the comments. Then stay with me, because the 11 minutes I mentioned at the beginning, the second mistake, is about to happen. Thomas Redfield presented the defense efficiently. The termination had been the client's prerogative as an employer. The wage dispute reflected a disagreement about the final pay period's calculation, not a refusal to pay. The personal property claim was speculative and could not be substantiated. He was organized, and he was quick, and he said everything that could be said. Then Daria Okonkwo opened her folder. She presented 6 years of time logs, every day, every hour, precise, consistent, dated, the kind of documentation that takes years to produce and minutes to verify. She laid out the final 2 weeks in detail, the specific dates, the specific hours, the specific tasks. Each entry cross-referenced to a corresponding entry from a comparable week the previous year to demonstrate consistency. She presented the state domestic worker protection statute, which she had printed from the government website, highlighted, and tabbed to the relevant section. It required a minimum of 2 weeks written notice for termination of a domestic worker employed for more than 1 year, or equivalent pay in lieu of notice. She had been employed for 6 years. She had received neither notice nor equivalent pay. She presented a photograph of the empty shelf in the laundry room where her container had been kept, taken on the day she returned to retrieve the graduation photo and found it gone. She presented the neighbor's written statement. And then she placed the $1 line item for the photograph at the top of the damages calculation page and did not explain it. She simply placed it there and moved on. She had been speaking for 14 minutes. She had not editorialized once. I looked at Vivian Colt. She was looking at her phone, not subtly, openly. The phone was on the table, screen visible, and she was reading something on it while Daria was testifying. I said, "Miss Colt." She looked up. I said, "Put the phone away." She put it away with the specific movement of someone performing compliance while communicating that the compliance is beneath them. I said, "Miss Colt, I want to ask you something directly. Have you reviewed the time logs Ms. Okonkwo submitted?" She said, "I've been advised by my attorney not to." I said, "I'm not asking for legal strategy. I'm asking whether you have personally reviewed the 6 years of documentation that the woman who worked in your home for 6 years kept on your behalf." A pause. She said, "I'm aware of them." I said, "Are you aware that they document over 6,000 hours of work performed in your household?" She said, "I'm sure they document whatever she wrote down." That sentence. I want you to sit with that sentence. Whatever she wrote.
Respect is not measured by wealth, but by how you treat those who work for you. Honesty, humility, and proper documentation will always outlast arrogance and power. Justice may take time, but the truth backed by evidence can never be silenced.